Thanks for coming, everyone. We have a small audience here because our primary audience is in rural and regional Victoria today, and I can see there's an audience building up in Geelong, Warrnambool and a number of other locations, so we're very pleased to have you here today. Officially on behalf of the Centre for Rural Regional Law and Justice at Deakin University and the Environment Defenders Office, I welcome you to our Rural Law Forum on the environmental, economic and social impacts of unconventional gas. My name is Maureen O'Keefe and I'll be your facilitator today. First, I would like to acknowledge the traditional owners of the many lands that we are meeting on here today. I pay my respects to their elders, past and present, and the elders from other communities who may be here today as well. And as we're sort of officially getting underway, let's see if we can get a little wave from each of the sites that have joined us today. So we've got Bairnsdale. Bairnsdale, like to give us a wave? There you are. Hello, lots of people from Bairnsdale. Churchill. Hello, Churchill. Geelong. Nobody wants to sit in the front row at Geelong, but that's okay. Horsham. A couple of people in Horsham. Yes, there's a hand. Portland. Hello, there we are, Portland. Shepparton. Where's our Shepparton? I thought I saw one hand at Shepparton. Yes, I can see one person there. Swan Hill. Thank you, Swan Hill. Warrnambool. Warrnambool's a bit in the dark. There's some mood lighting down there. And Mildura as well. Hello, Mildura. And our late addition is Hamilton, who were able to set up thanks to the council. Hello, Hamilton. So thanks for everyone. We also have some people listening via webcast, also in Mildura, Ballarat and other locations that we can't see, but we know you're there, so welcome along as well. Now, let's get underway. The environmental and social impacts of unconventional gas mining, including coal seam gas, are almost entirely borne by rural communities. But who stands to reap the benefits of the development of an unconventional gas industry? Environmental justice looks at whether the risk of environment harm is shared evenly throughout society and whether those who bear the risks of harm get a say in decisions about their environment. This forum will consider the concept of environmental justice as it relates to coal seam gas industry, which is currently expanding and creating controversy throughout rural Australia. We have a number of speakers we'll be hearing from today. First up, we'll hear from Dr. Jeremy Moss, the Social Justice Initiative, Melbourne University. We'll hear from Felicity Milner, who's the Principal Solicitor with the Environment Defenders Office. We should also hear from Professor Samantha Hepburn, who might be caught up in traffic, which would be surprising in Melbourne. And Glenn Martin from Shine Lawyers in Toowoomba will be joining us via Skype as well today. But first up, let's welcome to the lectern Dr. Jeremy Moss, from the Social Justice Initiative, Melbourne University. Dr. Moss is co-author of a recent report, Is Fracking Good for Your Health? And will speak to us about that today. Thank you, Jeremy.
Thanks very much for the introduction and for inviting me here to speak today. For those people in the room, I've just left a little handout. Sorry to go off camera for a bit. It's just a summary of some of the things that I was going to talk about in my presentation today. Look, as was mentioned, I was co-author on a report and a research project on unconventional gas that we ran at the Social Justice Initiative. And just to, basically today what I'm going to do about is talk about some of the contents of that report. But just a bit of background to that. One of the reasons we wrote the report is that Australia stands at a crossroads, and that crossroads in this instance is the crossroads that's been forced on us, I guess, by our upcoming energy choices. So in the face of trying to avoid dangerous climate change, we have to make some decisions about what kind of energy generation and fuel sources that we use if we're going to move away from coal in particular. And the current alternative seems to be gas on the one hand, particularly in Australia, or some combination of renewables on the other. So we're at the crossroads in the sense that we're going to have to choose, we will of course, and we are, doing and implementing or using both fuel sources, but as time goes on, we're really going to have to choose what the replacement is. And it seems to me, one of the things we argue in the report is that these choices are not quite a zero-sum game, in that if you choose one, you don't get to do the other, but it does seem to be heading in that direction. So what we thought we'd do in this report and in a report that's just coming out is look at the health impacts in particular of gas from extraction to combustion and indeed export, and compare that to the health impacts of, in particular, solar and wind. And we're doing this for obvious reasons, in that the Australian unconventional gas industry is set to expand rapidly it's expanding rapidly now, but the expansion will be even greater in the near future. And we wanted to put side by side the current evidence that is around in the literature for the health impacts of both renewables and gas. Why do we want to do that? Well, because the health impacts are, if you like, the trump. So they're the things that people seem most concerned about. And for good reason, okay? If something is unsafe, then we have very good reason to demand to know more about it, and ultimately to perhaps refuse to have anything to do with it. So what we do in the report is really do a literature survey of all the peer-reviewed evidence that relates to, in this case, unconventional gas, all the peer-reviewed evidence about its health impacts. So we're not doing primary research, we're not going out there and sitting at well sites and measuring the air and water quality and so on, but we're looking at the peer-reviewed evidence. And we also do a little bit about the fugitive emissions profile, that is, the emissions that are produced in the extraction and transport of unconventional gas to the place where it's combusted. And look, just for the record, I think the health impacts of unconventional gas are extremely important and very serious, and in my view, not enough is known to cut to the chase to permit this kind of expansion to go ahead, ideally. But I actually don't think the health impacts are the worst thing about gas, and I'll say a bit more about that. But they're certainly, as I say, the trump. All right, so what I'm going to do is just give a little bit of a survey of what we've found in the report and raise some moral issues. So as we said, I run this thing called the Social Justice Initiative. I'm in fact a philosopher, and my particular area of concern is moral and social issues, particularly around climate change. So what I'm going to do in this little discussion is give you some facts about the extraction of unconventional gas, talk about a little bit about the emissions profile of unconventional gas, summarise some of the health findings, and then move on to quickly mention some of the moral problems that are associated with the expansion of this industry. So there are a lot better places to turn than me for the big set of facts about the amount of acreage and so on of Australia that's under coal and gas licence. But I can tell you that it's around 437 million hectares of land, about half of Australia, is under some form of coal or gas licence. And in Australia, as many of you may know, we're the fourth biggest exporter of gas, and if all goes according to the gas industry's plan, we'll move up to number 3, up to the podium to get a medal, and be the third largest exporter by 2035 if much of the expansion goes ahead. So I think, well, and I should also say this report is available on my website, which is on the handout that most of you can't see. But that website, if you just go to the Melbourne University website and type in Social Justice Initiative, you'll find it by doing that. It's also on the website of the Australia Institute and indeed in a recent issue of the Australian Medical Journal. So the two big issues with unconventional gas are the emissions profile and health. And so just very briefly on the emissions profile. So the big claimed advantage about gas from a climate perspective is that when you burn it, it's about 40% better than coal. Better in the sense that it's less CO2 equivalent emissions. Okay, so if you just look at combustion, it's a lot better than coal, and it's a lot better than coal in a million other ways, in that it's a cleaner fuel, you don't get the particular emissions that go into the air and so on. However, the big controversy, as many of you may know, with gas is the fugitive emissions. So it's not just the emissions, the CO2 equivalent emissions that are produced when the gas is burnt that are an issue, but some of the gas, in the form of methane, escapes from the wells during extraction. Now, as far as I can tell, and I'm not a scientist, the science about this is very unclear. Okay, so some of the studies say that up to 9% of emissions, 9% of the equivalent total of emissions, or 9% more than combustion, escape from the wells when it's being extracted. Other figures put it down somewhere near 1%. Okay, so there's a huge range of figures, and there's almost no figures that have been produced in Australia. Most of the sources I'll be citing today are from the USA, some from Europe, but there's very, very little research on the emissions profile in Australia. Now, why I mention all this is because if it's the case that we're supposed to burn gas because it's cleaner than coal in terms of its emissions profile, if you actually have high level of emissions being produced when the gas escapes during extraction, it's not so clean as coal. And in some ways it's worse because the gas that escapes is methane, which is 20 times more powerful than CO2 when it hits the atmosphere. And that makes it more dangerous in terms of climate tipping points, which we're rapidly approaching at the moment. So you can look at that for yourselves in the report if you like. We have some discussion there about the emissions profile of gas. But look, on to the health issues. Again, what I would like to stress about these health issues is that there is a great deal of uncertainty. So that there's not any, as far as I can tell, piece of evidence that says, you know, this fracking will damage you beyond repair, that there'll be contamination of aquifers and all the other things. There's not that kind of smoking gun evidence. It's just too uncertain. However, a lot of researchers do and do agree on what the main risks are. Again, just to cut to the chase, because the issues are very large ones, a lot of people are worried about fracking chemicals, the chemicals that are used, that are inserted into the ground to break up the rock and coal formations and let the gas escape. Okay, there's a chemical mixture. Most of it is water, most of it is a vegetable extract, but there are all sorts of chemicals in there, which I won't go into name, that are themselves very, very harmful if you were to be closely exposed to them. That's one big risk that people are worried about. The other big risk is that there is somehow a contamination of aquifers, which is particularly important in Australia because that's where lots of agriculture and indeed rural and communities draw their drinking and water for agriculture. And there's worries that this fracking fluid will get into aquifers. And look, just to, again, cut to the chase, in my view, and what we say in the report, is that the chances of aquifer contamination are very low in Australia. They're very low. They're not non-existent, and they're very serious. If something was to happen to an aquifer, that's an extremely serious event. But that is one of the lower risks associated with the extraction of unconventional gas. In our view, the biggest risk is the contamination to at ground level and indeed to groundwater sources from the wastewater that comes up with fracking. And the wastewater is a combination of the chemicals that come up through fracking and naturally occurring radioactive materials like uranium, for instance. That is naturally in the ground and it's brought up by the fracking process. And often it's stored in big dams, and it's what happens to that liquid and the substances in the liquid when there's a dam failure, for instance, that I think is the biggest and most likely risk from unconventional gas. So let me stress that. I think some of the other risks are very serious indeed, but I think they're less likely than the wastewater issue. And indeed, just last year, well, just about 3 weeks ago, I think Santos was fined in New South Wales for a leak of its wastewater plant, just unfortunately, as we predicted in the report. So that's like a quick summary, if you like. So in a little more detail, there are various types of risk. So I've got about 2 or 3 minutes. Yep. Okay, there are various types of what we call risk pathways, and they are through water, through contamination of aquifer and other water sources, through the air, through fracking chemicals and others becoming airborne, through the land, that is through soil degradation and so on, and the social and psychological impacts of gas extraction as well. So just very briefly then, I'm not going to talk about all those kind of risks there in the report. What I will reiterate is that I think the biggest danger in terms of health from fracking is these naturally occurring radioactive materials that can come up during the fracking process and be deposited in wastewater, but also they can come up, they can become airborne, and they can affect people who are somehow quite closely located near a fracking site. But the wastewater issue, as I said, in my view, is the biggest kind of threat that we have from the health impacts of fracking. And we go into that in a great deal of detail in the report. And just to give you some figures, for instance, so sometimes with rock cutting waste and in the wastewater, you can get radioactive materials that are 25 times higher than they are found naturally on the surface of the earth, which is not a safe level. What I would stress about this is that there isn't much research on Australia about this. There's quite a bit in the US, but really what's important about that fact is what we do about it. Okay, so if there isn't enough research, we have to ask ourselves, well, do we have a good basis upon which we should proceed with the expansion of the gas industry? And it seems to me we don't. Okay, so what I would argue is that we should view this kind of issue as you would with a new drug. If one of you goes out there and invents a new drug and you say, look, we haven't got much evidence that it's safe, that it's unsafe, what do? We don't release the drug. We ask for more tests until we're certain, beyond reasonable doubt and whatever the standards are in that particular industry, that the drug is safe. And I think that's what we should be doing in terms of the health impacts of unconventional gas. Until there's been enough research to say that there aren't health impacts, it shouldn't be allowed to be expanded in the ways that it's currently being expanded. So I think there's a burden of proof on the industry which is not currently being met. Some of the other things that we also that are also raised by this kind of concern about health is the long-term impacts. And I say long-term impacts because, as I'm sure many of you will have read, there might be up to 10,000 wells drilled in Australia if all goes according to plan. What happens to these wells, which have a very short lifespan, is that they're then capped. They're capped, that is, they're blocked up with steel and concrete. And as everyone knows, steel and concrete are not geological materials. Okay, they don't last forever. They will break. They will decay. Who is liable for the wells then? Well, I'm willing to bet you next year's pay rise that it won't be the companies that did the drilling. Okay, it will be the public that bears the risk of that. So there's those kind of risks, and these are partly legal and regulatory issues that I don't think have, it seems to me, been properly thought through and borne out. The other big consequence that I think we face in terms of unconventional gas, and I'll finish on this point, is the opportunity costs that are borne by the community as a whole by pursuing this particular fuel source. So big companies don't invest in gas because they want to make make a profit next year. They want to get a return on investment that goes on for decades. And insofar as money is being sunk into one particular energy source, it makes it, I think, less likely that other energy sources, such as renewables, are going to be invested in. And so I think that is another big cost of the current push to expand the unconventional gas industry. So in conclusion, I think the health concerns, we don't know enough about them. What evidence there is shows that there are quite serious problems. And that means that we need to satisfy ourselves that these problems don't exist. And until we do so, I don't think the industry should be expanding in the way that it is currently. That would be my summary of what we found in relation to the health impacts of unconventional gas. Thank you.
Thanks very much, Dr. Moss. And what we'll do is, for all participants, we'll send you an email link to that report so that you'll also have the benefit of being able to find that report. And just a reminder, we will be taking questions at the conclusion of all the speakers. And if you do have a question or would like us to come to your site, the number to text a message to is 0427 659 140. And I will repeat that again. Our next speaker is Felicity Milner, Principal Solicitor from the Environment Defenders Office, who are helping us organise this event today. The Environment Defenders Office is an independent, not-for-profit legal centre specialising in public interest environmental law. Welcome, Felicity.
Good morning, everyone. So this morning I'm going to speak about three things. I'm going to firstly explain the concept of environmental justice. I'm then going to give an overview around the laws and regulations that apply when a coal seam gas or an unconventional gas project gets approved. And then I'm then going to discuss those laws and apply the concept of environmental justice to those laws to see whether our current laws do sort of recognise and provide the opportunity for environmental justice considerations to be considered. So there's been a lot of academic debate about what environmental justice actually means. I'm not going to go into that. I quite like the US EPA definition, which states environmental justice will be achieved when everybody enjoys the same degree of protection from environmental and health hazards and equal access to the decision-making process to have a healthy environment in which to live, learn and work. So environmental justice deals with two main issues. The first is environmental risk, or the risk of harm to a community's environment, distributed equally, and that looks at distribution amongst class, socio-economic groups, amongst geographical regions. In the US, it looks at it from a race concept, which I'll talk about in a little bit more detail in a second. The other main issue that environmental justice deals with is to what extent can communities participate in decisions about their local environment. So the concept first arose in the US in the 60s, and it initially started as a social movement. It was primarily a movement related to the racial equality movement, because there were a large number of toxic landfills located in areas that were predominantly African American. In the US, it also had quite a strong class or socio-economic aspect to it, again because toxic and harmful industry is overwhelmingly located in disadvantaged areas with a low socio-economic status. So that's how it started in the US. The US, it's now taken very seriously. 41 states out of all the US states have a policy on environmental justice. California has a specific law on it. When Bill Clinton was president, he issued a directive to all federal agencies that they had to take into account environmental justice considerations when they were making decisions. So in the US, yeah, it's a policy, it's a concept that's taken really seriously at a legal and a policy level. That's not the case in Australia. Australian environmental laws do, generally speaking, allow for participation by the community in decisions, to the extent that communities are generally speaking, and this is true for coal seam gas most of the time, communities are generally given the opportunity to make submissions about a proposal before it's approved. But the laws don't go beyond that. They don't say what weight those proposals should be given. They don't require the decision maker to take them seriously, or they don't necessarily have any effect on the decision maker's ultimate decision. So the decision maker has to consider those submissions, but they can then decide then not to give them any weight and not to allow those submissions to affect their overall decision. The other aspect of environmental justice that I mentioned, the one about where the risk of harm to health and environment is fairly distributed, is not really covered at all in Australian environmental laws, including the laws about coal seam gas. So as we've heard, coal seam gas and unconventional gas there's a serious risk that it could have serious health and environmental impacts. It can potentially also impact on people's local environments, and also in the context of an agricultural community that relies on groundwater, it can potentially have significant impacts on people's livelihoods. So these issues need to be addressed in any regulation around coal seam gas and unconventional gas. And unfortunately, in my view, under our current laws and legal systems and regulations, they are not very well addressed. And I'm now going to move on to the second part of my talk, which is to give you an overview of those laws and regulations. So before any coal seam gas or other unconventional gas can go ahead, a licence, I should just point out, mining laws, so the Mineral Resources Sustainable Development Act regulates coal seam gas. Shale gas and tight gas, which are also unconventional gas, are treated as petroleum under the law. So the legal regimes are a little bit different. I'm going to focus on coal seam gas. And I should point out that coal seam gas and the mining laws give slightly more opportunity for the community to be involved in decisions than under the petroleum laws. So if you think that the laws around coal seam gas are inadequate, you can also know that the laws that regulate, or the petroleum laws basically, are worse. So you need a licence before you can begin to explore or mine for gas, for unconventional gas. Under the petroleum laws, that's actually called an exploration permit and a production licence. Under the mining laws, it's called a mining licence and an exploration licence. In the case of mining laws, the applicant for the licence applicant has to give notice that they've applied for a licence, and then people do have the opportunity to comment in relation to those licences. In the case of a mining licence, all the landholders actually directly get written to and have the opportunity again to make submissions, and can also ask for an inquiry, trigger an independent inquiry process in relation to whether agricultural land or using the land for mining is of more economic benefit to the state. So there are a couple of important provisions that allow for community participation. But again, even though the community can take can make submissions, and the Minister is required to take those submissions into account before a licence is issued, there's nothing in the law saying that the Minister must give determinative weight to those submissions. There's nothing in the law saying that if a community overwhelmingly is against coal seam gas or unconventional gas going ahead in their community, that the Minister has to make that a real factor in his or her decision, and potentially give the community some ability to determine what happens to their local environments. Before the operation can go ahead, after they get the licence, they also, except in the case of low impact exploration, they have to get a works plan signed off by the department, which is currently the Department of State Development, Business and Innovation. So this plan has all the details about how the mining or the exploration operation will go ahead. This approval is given behind closed doors, so to speak. The department gives the approval. It's not publicly available until the approval's been issued. Once it is issued, it is available, but the public has no opportunity to have input into that works plan, and that could cover their land. It could cover activities on their land, and they have no opportunity to say how they feel about that. Some, and probably most mining, but not exploration, will require an environmental impact assessment process, either through the planning laws or under the environmental effects statement process. If it does go through either of those processes, again, there'll be the opportunity for the community to make submissions, but again, that opportunity to participate doesn't actually equate to giving them real power and weight into whether or not something goes ahead in their community. The final main regulatory step that must go ahead before mining or exploration can actually happen is that they have to get access from the landholders, and I think Sam's going to discuss some issues around that, but basically it's a negotiated process. The landholder can say no up to a point, but then if they do continue to say no, there is the opportunity for the mining company or the gas company to go to the Victorian Civil and Administrative Tribunal and actually impose access on a landholder. 2 minutes. Thanks. So in sum, I think as I've probably already mentioned, there's currently the rural communities who are bearing all the health risks and the environmental risks, and the beneficiaries who are primarily the gas companies and arguably the government because it gets royalties. There's a disconnect and there's an unfairness, I think, in the way that the coal seam gas industry expansion and the laws that regulate, they don't address that unfairness. So there's currently no additional protection, there's no recompense or compensation to communities for bearing that health and risk burden. Landholders who have the actual facilities on their land do get some compensation for that, but the community as a whole, which may be affected by the groundwater and the other health impacts, are not given any recompense or any, that sort of unfairness is not dealt with in the laws. The laws also, although they allow the community some rights of participation, as I've said, we've seen in Gippsland where communities have voted, upwards of 95% saying that they don't want this industry in their town, in their local area. And that is something that the government can disregard. So even if a community is overwhelmingly against something and that putting it ahead might create all sorts of social or social disconnect within the community, it can still be, the industry effectively can still be imposed on those communities. So I think that that's another issue that the laws should address. So I think that in some, environmental justice would be quite a useful concept for addressing some of the, or quite a useful framework for addressing some of the deficiencies in the current laws around coal seam gas, which I think are contributing to the current controversy around the industry's expansion.
We need all the people to applaud loudly on behalf of the others as well. Thanks very much, Felicity. Our next speaker is Professor Samantha Hepburn, who's Associate Head of Research at the Law School of Deakin University. Professor Hepburn has published widely on the topic of coal seam gas, most recently exploring the implications of the Victorian Gas Market Task Force report on unconventional gas development in Victoria. Thank you.
Thank you. I've actually got some of the concerns we have at the regulatory level, particularly with respect to land access, compensation and integral review, and I've just summarised some of the key points here. Resource conflict, discontent, resistance, the regulatory approaches, as I think we've mentioned to date, has been a bit reactive, ad hoc, certainly lacking the policy coherence of environmental justice. We need much greater emphasis on the interface, particularly for surface owners. So owners, private owners, who are affected by coal seam gas applications or shale gas applications, need to have a greater awareness of what their rights are. When they say no, does that necessarily mean that they are saying no? Sometimes they can have consent being presumed through compensation agreements. So we need to have a much greater emphasis on how the interface should be regulated, and obviously incorporate that provision for a sharing of economic gain. Now, the Victorian Gas Task Force report was issued late last year. It had 19 recommendations. The overall aim was to promote competition, liquidity and transparency in the eastern gas markets. What we saw was a strong emphasis on economic development and a weaker focus on social licensing issues. When I say social licensing issues, I'm really talking about access, compensation and concerns that private landowners have with the rapid expansion of unconventional gas in Victoria. Now, what we've got is feedback on the report until March 2014, and that's apparently going to be followed by a comprehensive consultation process with communities and individuals affected. What are the key recommendations? Removing the moratorium on the issuance of new exploration licences for CSG, implementing leading practices from the National Harmonized framework, which is obviously at a Commonwealth level, engaging landholders and communities via the creation of a new office, which would be a gas commissioner, and establishing, and I've just put 4 of them out here, establishing an independent water science program, which would operate with the Commonwealth Independent Expert Scientific Committee. So they're 4 key issues. Are they effective? Is it working? Sorry, a couple more. A royalty for regions program. that would give a percentage of royalties to councils for designated community projects, a bit similar to what's happening in Queensland, and raising the upper limit on compensation claims from 10,000 to 20,000. Okay, weaknesses. I'm just going to focus on the weaknesses here. Basically, too much focus on economic initiatives, need to develop a social licence, as I said. Where's the access code? We need regulation regarding the way in which access is implemented, negotiation, protection against disturbances, all these sorts of important clarification rights. We have an access code in New South Wales, we have an access code in Queensland. It wasn't recommended here. It would certainly complement the role of the Gas Commissioner. And also, of course, there doesn't seem to be a strong emphasis on the implementation of credible, focused, detailed environmental review processes. So access code would seek to prevent conflict. It would work efficiently with the Gas Commissioner, and it would regulate issues such as social disturbances, outlining detailed time, place, scope of access. So really important. It is a significant omission in my opinion, and hopefully it's something that we can consider. Okay, I'll just to mention that the Queensland Access Code is quite significant in terms of the mandates, entry notice, communication between the parties regarding the nature of the property, the location of the mining, water supply, property information, biosecurity issues. Really important detail. Look, I just briefly mentioned the resource ownership framework. For those of you that don't know, basically subsurface minerals are vested in the state or the Crown. So we have a public ownership framework which effectively allows the state to issue licences, as Fiona has just said, to companies that want to exploit unconventional gas. So the issue here is this, and can't help it, being a property lawyer, you have to go back to these sorts of issues. Hang on a minute. Ordinarily, you own the strata, you of course own the land, and you own everything within the strata. So what's happened here under the public ownership framework is we're separating out the minerals that exist in the strata and saying, well, one person owns that publicly, and we are able to set up a licensing framework, and another person, if it's private land, owns the fee simple or whatever the estate might be. Now the difficulty is, as I said before, that interface. How do you set up the boundaries of each ownership right? This is where the core problem lies. So even if the state owns the minerals, what sort of ownership rights do you have? How does that extend to the surface? What sort of access entitlements? Do we just purely regulate this by statute? And if so, what sort of protection does that give the other ownership rights that reside with the surface estate owners? So these are the concerns that exist and that have been well researched regarding a public ownership framework. We can contrast this significantly with the United States, where we do not have a public ownership framework, where the minerals continue to reside with the private estate owner, but what they can do is sever those minerals, transfer them over to a mineral company and set up a mineral estate. So it's a different type of regime, which probably is a bit more intuitive than trying to somehow separate out two rights that reside together. Oh, next one. And I've got 2 minutes. So in 2 minutes, I might just run to basically one of the issues under the current regulatory regime with access basically lies in the fact that where you've got issues regarding consent, yes, you have to seek consent. If consent isn't given, as Fiona said, the mineral company can simply go to VCAT and get consent. So it's not really a right to get consent. There's no right to veto. You can't say no, basically. And even if you do say no, the mining company will go to VCAT so that you get a yes. Right? Now that's problematic. The other problem is that you get a lot of issues relating to implied consent from a registered compensation agreement. And one of the arguments is that maybe we need to separate out compensation from access and consent issues, so we've got clarity for the surface estate owner. when I say I mean private owner. Okay. Okay. I've mentioned rehabilitation and notice, but we might just move on to the next one. So keep going. I wouldn't mind just quickly getting up to compensation. Okay, here we go. I just mentioned the compensation framework for landowners. For loss or damage directly resulting from mining, this is under the Mineral Resources Sustainable Development Act and the PA, and the compensation includes deprivation of possession, damage to the surface of the land, damage to improvements, loss of amenity or opportunity, that's a big one, but it certainly doesn't include loss of the mineral because the mineral doesn't belong to you under the public ownership framework. Now, the question is this enough? We know that the Gas Task Force report has increased loss of amenity from $10,000 to $20,000. Is that enough? Maybe not. And it depends on what we're talking about when we look at loss of amenity. We can talk about significant interference. We've got some protections under the MRSD in that drilling can't occur within 100 metres of a private dwelling, although I note that the reform bill suggests that the minister might be able to overturn that. But we haven't got much protection in terms of the issuance of these licences. And looking at impact, what sorts of things could impact you? I mean, Jeremy's just looked at the health concerns that are associated with that. The compensation is strictly related to surface estate industries, loss of amenity, not loss of the mineral. One other query is whether or not damage to subsurface which could generate problems in the future if you've got some sort of depletion of the subsurface aquifer or potentially some sort of contamination. How is that in the future going to impact upon your surface estate? That's not really covered in the compensation framework. And this may well get down to the problem that we've got, which Jeremy has alluded to, that ultimately we're trying to adopt a predictive model, but we don't have the research yet to really evaluate at this stage what might happen in the future. Okay, finish there.
Thank you. As you can tell, all our speakers are extremely knowledgeable and could talk for hours and hours and hours, and we're giving them like 10 minutes to do that. So we will be following through by ensuring that you have links to a lot of this information, so you'll be able to follow through. And we have one more speaker, and you just have to bear with me for a moment because he's joining us via Skype from Toowoomba. So just bear with me one moment while I get him up online. Okay, we're getting a little bit of feedback there, Glenn, but I think we can hear you okay. So Glenn Martin is from Shine Lawyers in Toowoomba, and he works with landholders in southeast Queensland affected by the energy and resources industry. He's witnessed firsthand the impacts of the coal seam gas industry on rural communities and how the legal system relates to landholders and communities affected by coal seam gas. We have got a bit of wind noise coming through there. So Glenn, what I might ask you to do is to actually mute your speakers for when you're talking so that you won't actually be able to hear me in a moment, but we can hear you, and that'll help. So Glenn, welcome, and let's hear from you now.
Thank you and good morning everyone. Thank you for inviting me to speak this morning. Can you hear me?
Yes. Yep.
Righto. I've been practicing in the area of mining and coal seam gas now for over 5 years. I've been a solicitor for much longer than that, of course. The coal seam gas industry in Queensland is much more developed than in any other state. I understand that Victoria is still very much in its infancy. New South Wales has been some recent activity, but it has been somewhat put on hold, although Santos are proposing some significant development around the Narrabri area. But certainly in Queensland, we've now been going full steam ahead for many years. We have had 4 main players here, QGC, Santos, Origin and Arrow. They've all proposed major export facilities from Gladstone. And the main area of their production has been in the Surat Basin, which is west of where I am, which is Toowoomba today. I'm in Toowoomba now. The Surat Basin is a relatively large and very productive area of the state. It includes part of the Darling Downs. So that area is roughly about 200, starts at about 200 or so, or 150 to 200 kilometres west of Brisbane. So these projects are enormous projects. They range up to $20 billion for any one of the projects. And there's 4 players, although in recent months Arrow Energy have dropped out of the game, it seems, so we're left with 3 main players. These industries have a devastating or significant, rather, impact on the communities in which they exist. There's no direct ability in Queensland for individuals or communities to determine whether or not CSG exploration, production or facilities go ahead in their area. As the previous speakers have indicated, the same will apply in Queensland, or does apply in Queensland. The Queensland Government holds all, or practically all, relevant power with respect to CSG development approval, except the Commonwealth does hold some very minor power, if you like, with respect to matters of national significance, which more recently has included projects that will have impacts on certain water resources. So the Queensland Government controls entirely the grant of the tenure, so that's the grant of the petroleum licence, or petroleum lease as we call it here, plus the other tenures that might be granted like authorities to prospect. They also control entirely the grant of what you've also heard in your state, environmental authorities. So we have 2 things. We have a petroleum tenure, like a petroleum lease, an authority to prospect, and on the other hand, we have an environmental authority. There's no ability of communities or individuals to have a say in the grant of the tenure. There is, however, an ability of communities to have a say in the conditions of the authority. So the environmental authority talks about and controls how the companies must go about their activities, how many wells they might drill, how many ponds they might have to hold their water, how many reverse osmosis plants, how they might control erosion, how they might control noise, dust, light, how they might control a whole range of factors. And their environmental authorities contain many, many conditions. I have one here which of course you won't be able to see, but it's something like an 80-page document with various conditions in it. Communities and landholders can usually have a say, or typically have a say, in those conditions. And they have a right during the application process for the environmental authority to make submissions on it. If the application or the project is of a nature that, to put it in easy understandable terms, is a high-risk venture. So where the project's going to involve some significant risk, and most or a lot of these CSG projects do involve that, so communities and landholders will get the opportunity to have a say in the conditions of the environmental authority, and they can make a submission. If they don't like the environmental authority as it comes out, they can typically or often they will have a right to have that decision reviewed, and if they don't like that decision, then they can sometimes appeal to the court the decision. Quite a few landholders and community groups have taken the opportunity to make submissions. In fact, it would be quite common for people to do that and community groups to do that. It's less common for communities or individuals to go the next step and appeal the decision. We do have one that I'm aware of in Queensland, and probably about the only one with respect to CSG, and that involved an application for an environmental authority by Arrow Energy over our highly productive agricultural land on the Darling Downs. And a number of landholders appealed the decision of the department and went to court and had the court make determinations with respect to the environmental authority. And it would be fair to say that the Environmental Authority was still granted, but with amended or altered conditions. Of course, Arrow Energy now pulled out of the field, so that was a process that went ahead, and we're not entirely sure why Arrow Energy have decided not to continue with their operations. I suspect there's a bigger picture issue involved. There's currently legislation before the Queensland Parliament to provide local councils with authority with respect to what's known as priority living areas. If the legislation passes, it'll mean that local councils will have authority to decide if they want CSG close to residential areas. Coupled with that legislation, there is also discussion about not allowing CSG on priority agricultural areas. We have in the past had legislation that talked about strategic cropping land. However, that never really got off the ground to any extent. It was introduced by a former government, and the new government has come in more recently and decided to scrap that and introduce this whole new regime of priority agricultural areas. There's still some concern as to how effective that will be. Some people say it's not going to be effective at all. In terms of the rights and powers of communities and landholders versus CSG companies, I don't want to traverse too much of what's been said previously, but in Queensland, as it is in most other states of Australia, it's the state that owns the minerals and CSG. And it has the right, the state has the right, to authorise people to extract the minerals and CSG, even where that might involve interfering with the rights of owners of the freehold or crown lease of land. So under the petroleum legislation, once a tenure is granted, the tenure holder can come in and undertake the activities constrained only by a number of things, including its tenure. So it can only, if it has an authority to prospect, it can only prospect for petroleum, and that would typically include doing things like drilling exploration wells, core holes, seismic surveying, and a whole range of other things as well. If it has a different sort of tenure, and one of the more common ones is a petroleum lease, that will enable them to produce petroleum. So it will enable them to do all the exploration activities, plus doing things like drilling a production well, putting in a pond, putting in field compressor stations, those types of things. So the company will be able, if it's got that tenure, it will be able to enter, providing it's allowed to do the activity it wants to do, and providing it complies with what we call the land access laws. And the land access laws, in a snapshot, provide this. If the company wants to come on and do preliminary activity, all it needs to do is give the landholder a complying entry notice. And the entry notice really just needs to say what we're going to do, where we're going to do it, and when we're going to do it. Unfortunately, the companies rarely strictly comply with that, and I see all manner of entry notices given. The company, after giving that notice, all it needs to do is wait 10 days, and then it can come on and do its preliminary activities. And preliminary activities means activities that are going to have no effect on the landholder or only a minor effect. So that typically involves things like driving in with a couple of four-wheel drives, having a look around, scouting what it wants to do, working out what it wants to do, talking to the landholder, kicking a bit of dirt, putting some pegs in the ground to mark out its roads, wells, pipelines, that sort of thing. If the company wants to come on and do advanced activity, so activity that will have more than a minor effect on the landholder, so drilling a well, doing seismic surveying, that type of thing, it will need to follow the next set of procedures, which will involve typically giving the landholder a notice of intention to negotiate and a conduct and compensation agreement. And the landholder and the company have 20 business days minimum to negotiate that agreement. If at the end of that 20 business days the agreement hasn't been negotiated, then the matter gets referred to the alternative dispute resolution. If it's not resolved within 20 business days, then the company can give an entry notice to undertake advanced activity, and 10 days after that it can enter the land, and the matter gets referred by either party to the land court to determine compensation. So the legislation is quite stern and quite strict, and many think it's very much in favour of the CSG companies. It gives them an actual right. All they need to do is follow the legislation. In Queensland, I'm reasonably comfortable though from a landholder's perspective, and that's who I act for. I don't act for any mining companies or CSG companies. I'm reasonably comfortable with the way the legislation is at the moment from a landholder perspective. It's not perfect, it's not great, it could be better, but sometimes we have to compromise on these things, and as it stands at the moment, it's a reasonable compromise, although the balance does definitely tip towards the CSG companies. There are a couple of other little things that CSG companies need to be aware of and that landholders need to be aware of. A landholder must not unreasonably interfere or obstruct a tenure holder from entering or crossing the land. If they do, they will have committed an offence. The reciprocal provision for CSG companies effectively is that they can't carry out an activity in a way that unreasonably interferes with anyone else carrying out a lawful activity. That's not yet tested in Queensland, but it's something we, as landholder lawyers, trumpet and we press for. So it means effectively if the gas company wants to do something that you as a landholder would say is going to unreasonably interfere with your activity, you would be quite right to say, no, it cannot occur. We haven't tested it in court yet, and in time we may do that. Further, CSG companies are required to comply with the terms of their environmental authority that's been issued to them. So while they can come on, they've still got to comply with their environmental authority. For example, there are restrictions on noise levels at sensitive sectors, and there may be constrained areas about where they can and where they can't go. They might have dust control measures, and all of those sorts of things might prevent them from doing activity within a certain area. But as a general rule, the companies can come on.
It's got 2 minutes.
Can you still hear me?
Yep, 2 minutes. 2 minutes.
Righto. Examples of injustice occurring, there's lots of them. Companies, for example, exert enormous pressure on landholders. And here we're not just talking about one well the size of a football. Some people might have seen TV advertisements about CSG only taking up the size of a basketball court rather. That is quite an exaggeration in my view of the real position. We're talking about hundreds or thousands of well sites, roads, thousands of kilometres of pipelines and gathering systems, field compressor stations, central compressor stations, pumping stations, reverse osmosis plants, camps, ponds, export facilities, vehicles upon vehicles, noise, light, dust, gas, people upon people, buildings upon buildings, extensive clearing of land and use of resources and so on. These are highly intrusive activities. To think that it's just a basketball court here and there does not understand the activity. And so what happens is communities are inundated. We have little towns west of here that were once sleepy communities are now turned into bustling, dusty cities. Effectively, perhaps not cities, but very, very busy towns with trucks and vehicles going in all directions. So the activity does also tend to fracture communities. you have some that want the activities, you have some that don't want the activities. Some adapt very well to the activities and even prosper by it. Some people have done enormously well out of CSG activity. Others have not done so well. They go to their local shop and find that prices have increased. Their rent has increased. They can't find somewhere to rent. The roads are so busy and potholed that they can hardly drive on them. One landholder was telling me that she had 4 tyres in the space of a week due to the condition of the road and debris being dropped on the roadway. The costs involved to any individual landholder can be enormous sometimes. Even though we have a system in Queensland where companies are to pay reasonable and necessary legal costs of negotiating agreement, that doesn't always occur, or there are costs that you're never going to recover. Time in dealing with resource companies is enormous. I couldn't overestimate the length of time that any particular landholder will have to deal with their resource company. It'll typically be that the landholder will have to prove his loss. And that is not always easy to do, and some items are not compensable. We have a set regime of things that you're entitled to cover, and some things that you might think are recoverable aren't recoverable. So it seems to me that what happens is communities get an activity imposed on them, it's significantly intrusive, and they have no say in the issue. Some people can do well out of it, some won't do so well out of it, some will do very poorly out of it. Individuals are having their freehold land, they feel, invaded and have no right to have a say in that. I think landholders do need to stand up a bit more at times and have a say, but I can understand why they don't. It's incredibly onerous to do that at times. We have a little community here called Tara, and it involves, it's a community that has lots of little rural subdivision sites of about 20 acres. And the social economic background to it is perhaps not all that good. The people, just a couple more minutes if that's okay?
Yeah, just 1 minute if we've got time for questions.
From a very low social economic background, very small blocks of land, and what has happened is a CSG company has moved in there and drilled wells on them and caused them immense anxiety and problems. And you'd only need to Google Tara, T-A-R-A, it states, and to find some of the issues that have arisen there. There are lots of health concerns arising out of there. There are lots of concerns regarding pure access issues and disturbance to those landholders. They simply want to be left alone and not have a gas well beside them, drilling activity, disturbing their otherwise peaceful lifestyle. That's perhaps about all for me at the moment.
Thanks very much, Glenn.
I'm happy to take questions from now.
Yes, we'll be going to questions now. So we thank Glenn Martin from Shine Lawyers in Toowoomba, who for giving up his generous time today and providing that insight. I noticed lots and lots of people taking notes, so if we can have a round of applause at the moment for all our speakers so far. And we will be going to questions, and with everyone taking lots of notes. I've had a question about whether we can get a copy of your slides, Samantha, so we can distribute those. I'm getting a nod there, which is great. Now, Dr. Jeremy Moss needs to leave us in a few minutes, actually, so if there's any burning questions for Dr. Moss, if you would like to text those into 0427 659 140, 0427 659 140. We'll take about 15-20 minutes worth of questions now, and we've got a few that have already come in, and for our speakers on the panel, those microphones, you'll just need to switch those on and put them nice and close to your mouth. when you get to speak. Now, there's a question here, where is the Victorian Government in terms of its review? Who is conducting the review? I'm not sure what review, but maybe Samantha, just turn that mic on. It's just on the front there. Yeah.
Okay.
That's all right, it'll start.
Well, the Victorian Task Force report was issued late last year, and that's in a period of getting recommendations and submissions at the moment. That will go till March, and then following that there is going to be apparently extensive community and stakeholder opportunities, and so I would imagine probably later this year we'll have significant decisions regarding the recommendations. There's also a Mineral Resource Sustainable Development Bill that was introduced last year in 2013. It hasn't been passed yet.
Thank you. A couple of other legal questions. What conditions apply when an exploration licence is suspended? I'm not quite sure what the rest of this mean, but is planning for a PEP 168, if that means anything to anybody. Does that mean anything to anybody? Yep, looks pretty good. Should be on there, yep.
PEP is a production licence, or it's either a production or an exploration. No, an exploration permit, for petroleum. So that would be, if it's gas, that would be tight gas and shale gas. I don't know where 168 is. And I'm not sure if it has been, I mean, if it's been suspended, the conditions will remain in place and they just won't be able to do anything under the licence. I'm not sure if that answers your question.
Sorry, Glenn, if I could just ask you to turn off your speakers at the moment, so we're getting a bit of feedback there, and when we come to a question we can pop those back on. That would be great. Okay, so not too certain on that one. And we have Adele from Meetung. Stringent codes may exist, but what happens when they're not adhered to? Are there inspections to follow through?
Well, it depends on whether the provisions are mandatory or aspirational. There is that dichotomy in both the New South Wales and the Queensland Code, but mandated provisions regarding negotiation, timing, place, disturbance, they're generally the sorts of provisions that have been mandated. And so if they aren't complied with, then you have to look at what the regime for enforcement might be. I suppose what's being asked is, can we in any way suspend or somehow extinguish the tenure? That would be unlikely, okay? But there may be other provisions that allow some form of compensation or possibly a penalty on the and then is that effective? That's another question.
A further question, and then I'll actually come to Bairnsdale if there's any direct questions from Bairnsdale, because I know we've got a large contingent there. Will the national harmonised regulatory framework address the concerns on environmental issues?
From my point of view, I would say no. I think that, again, that framework is primarily around facilitating industry expansion, probably in a slightly more consultative and a slightly more rigorous way, but I don't think it addresses that fundamental issue. Firstly, that we haven't got enough research, so the uncertainty in terms of environmental impacts remains. And secondly, it doesn't address that fundamental issue that if communities don't think that the potential impacts on their environment are acceptable, there'll still be very little that they can do under that framework. So I don't think it addresses those two key things.
Glenn, can I just ask you to turn your microphone off for the moment, please? Sorry, there's just a bit of a loop happening there. So that just will help a little bit. Thank you. I'm sure there'll be more questions coming in. I wanted to go to Bairnsdale, though, because I know that there were a number of people in Bairnsdale. Do we have any specific questions from Bairnsdale? You can turn your microphone on and hold it down if you have a question, and then turn it off to hear the answer.
Yeah, oh, sorry. My name's Adele, and sorry, I've already asked a question, but I've read about some of the states and the Commonwealth being in a partnership agreement for the progression of selling gas to India and China, but they have to do these bioregional assessments, which will then sort of mitigate the environmental effects statements for going ahead with coal seam gas and tight gas mining. Are you able to expand on that at all?
I'm not entirely sure what you're talking about. If you're talking about Victoria, the environmental effects statements need to be done where a public work is involved, and as Felicity said, they're quite discretionary, they lack rigour, there's not a lot of criteria, and this is hugely problematic. But in terms of bioregional assessment, I know that there's the Strategic Land Use Plan framework and the Gateway framework that's been introduced in New South Wales, a slightly different, overview. Probably similar to some of the legislative initiatives that Glenn was talking about in Queensland as well, where you're starting to evaluate strategic biophysical land and determine what sort of activity should be allowed on that land. Certainly in New South Wales, if it's strategic biophysical land, then you have to, the process for environmental review, the Gateway process, is far more rigorous than if the application or the project application doesn't apply in those areas. So that's sort of one aspect. I'm not sure about the arrangements internationally with India. I'm unsure about that.
I think Glenn had a comment. We'll come to you in a moment, Glenn, but we just have one question for Jeremy before he has to leave, and it comes also from Bairnsdale. Why are fracking chemicals not extensively named?
I'm not entirely sure, to be honest. I think, so there's two issues. One, I think most of the fracking chemicals are known. The issue is whether it's known whether they're being used in a particular instance. So we have quite a good understanding of what the fracking chemicals are and what sort of health risks they pose under different circumstances. So we do know that. I'm not entirely sure why companies aren't forced to name the particular chemicals that they're using. I don't know that. Maybe someone else on the panel.
The only thing I would say is that there has been some regulation. Obviously, you'd be aware of this about the type of chemicals that can be used. So it used to be unrestricted, and now it is restricted. But in terms of why the chemicals aren't actually named, that would be a regulatory failure, I'd say. I don't know any provision that requires that, so maybe that's something that also needs to be examined.
Good question there, and I think with that note you need to leave us, Jeremy, is that right? I do. So thanks very much again to Dr. Jeremy Moss, who has to get back to the university for giving up your time, and we will be passing on Jeremy's links there so you can read more from his report. Thank you once again. We have a question, and I think perhaps Glenn, you might have some insight into this given how far you've progressed there. It comes from Swan Hill. What rights do Indigenous communities have to say no to fracking? What, if any, are there culturally significant sites they want to explore? What happens in the Queensland setting at the moment?
I'm not a lawyer that represents the Indigenous community, so my knowledge on that is limited. But what I can say is this, that we do have an Aboriginal legislation in Queensland that protects Aboriginal culture. And before anyone in Queensland undertakes certain activity, they have to be sure that they are not causing or going to cause any harm to Aboriginal culture or heritage. And that extends to CSG companies as well. And so when CSG companies go onto a property to investigate what they want to do, they need to be assessing the situation in terms of Aboriginal cultural heritage. And it will involve sometimes landholders, Aboriginal Indigenous landholders entering into land use agreements with CSG companies, and we see it sometimes where there is a notice put in the paper where a particular CSG company wants to go and do CSG activity in the area, and inviting the Indigenous community to enter into agreement with them. It can be quite an involved process, so I think it's fair to say that there is legislative protections there to require companies to consider the Aboriginal cultural heritage and enter into agreements with them. In terms of fracking, well, that would be part and parcel of it. But in terms of the specifics, I've never been involved in doing an Indigenous land use agreement or representing Indigenous communities.
Thanks, Glenn. Felicity, is there any legislation sort of from Victoria's perspective that would be considered for Indigenous communities?
Yeah, so there is, it sounds like broadly the same system. There is an Aboriginal Cultural Heritage Act which protects Aboriginal cultural heritage. To some extent, as in you can't destroy Aboriginal cultural sites or objects or places that are significant to Indigenous people, but that's so until you get a cultural heritage management plan, and then essentially you can't do it without permission, but you can get permission to destroy these objects. You've just got to go through a process. So there's some protections in there, but I'd imagine that a lot of Indigenous people would consider that inadequate.
We're getting lots of questions now, and we've only got about 10 minutes to go. But another question for you, Glenn. What, if any, rehabilitation has been undertaken on exhausted well sites? Have you any idea about that one?
Yes. Well, there's not really been any petroleum production or CSG production well sites that have been exhausted. The companies are required to undergo rehabilitation on a progressive basis, so the sites themselves are sometimes progressively rehabilitated. So if they don't want a particular site anymore, then they will do what they can to rehabilitate the site. But we're not seeing production wells going into that rehabilitation phase yet. We're still a long way off that. But some of the exploration holes, yes, we're seeing that. What's happening? Well, there's two issues, I suppose. One, what do we do with the well itself? That's supposed to be plugged and abandoned. And I think it was Felicity earlier that spoke about the plugging and abandoning of it and the problems that can arise there. I think we're a long way short of seeing what's going to happen in 30 years' time when the steel bore casings rust out, the concrete deteriorates or cracks, and we get interconnectivity between water aquifers. We see any remaining gas start to rise to the surface. The time will tell on that. There's all sorts of rules and regulations for decommissioning these, but whether it's effective in the long run, I'm sure only time will tell. In terms of the land, we are seeing a rehabilitation of the land occurring. Rehabilitation of the land itself probably isn't an enormous issue with CSG. Because of the nature of the activity, it's not equivalent to coal mining, so the land can, to some extent, be rehabilitated. But some of this land is quite fragile as well. Some of it just should not be disturbed at all. It's very light soil, heavy vegetation under it, and we're running bulldozers through it, and it can take years upon years to revegetate those areas. In fact, the more you try and revegetate it or rehabilitate it, the less likely it will be to revegetate. One problem is, of course, where you have pipelines that require the earth to be dug up. With respect to CSG wells, you don't, as a general rule, need to dig up the soil, although you will if you need to have a flat pad, you'll need to cut and fill it. But that is a relatively small area. But the pipelines extend for hundreds of kilometres, 40 metres wide, and we're still seeing problems with rehabilitation there in some places. I have manholes that are years later complaining about the rehabilitation that's been undertaken. The topsoil is mixed with the subsoil. It's not put back right. You've got, it won't all compact back in. If it does compact back in, it might compact too far. It has channels, it has gullies. So, with respect to roadways on property, how do you construct the roadways? Getting them rehabilitated back to the original state can be a big problem on particular land types.
Thanks for that.
I'm afraid that fracking will be presented as the great salvation of this city at the expense of a whole lot of the safeguards that set inadequate, as it says, the safeguards that need to be in place before it's widespread. So let's say, hypothetically speaking, all of the safety and health and regulation issues were resolved. What sort of employment prospects does the industry realistically present?
Thanks, Geelong. For the benefit of others who might not have heard that question, there was a comment. It was in relation to Geelong in particular, with the closing of major industries, whether fracking would be presented as a viable option for employment. Thanks. We'll just turn that microphone off and get a response from Felicity.
I'm certainly not an expert in that area, but I just wanted to say the Australia Institute has just released a pretty comprehensive report which is free and available for downloading on their website. So I suggest that you have a look at that. I think very broadly it's fair to say that fracking doesn't provide the employment opportunities that mining does. So I don't think it would be realistic for a coal seam gas or an unconventional gas industry to pick up all of the jobs lost resulting from Alcoa shutting down, for example.
Thanks very much. I forgot we had a question in advance, and then I will come to Warrnambool, I promise. It's kind of related, and it's a question about trespass, I guess. One question is about having a lock the gate sign and whether the gate has to be shut for the sign to be effective as a no trespass to mining companies.
Okay, I think I mentioned that there is no right of veto. No right of veto. So, you can put a lock the gate sign on, but that doesn't necessarily preclude companies with exploration licences and certainly licences that have statutory entitlements to access from entering. There are, as we've mentioned, notice of entry and consent requirements, but they're not necessarily going to protect landowners, particularly where companies have gone to VCAT to get that access entitlement. So in the absence of an access code, which would regulate the way in which that access is implemented, landowners can find themselves in vulnerable positions, even if they do lock the gate up.
And there's a related question here, and I'm not clear whether it's just a general member of the public out of curiosity, but are you allowed to go on the property of a farmer that the company have an exploratory well on? So I guess whether it's a general member of the public, I'm not sure if there are secret protesters there or whatever going on, but can you actually go on the property of a farmer if there's an exploratory well there?
Well, it should be mentioned that mining tenures are exclusive in nature, so they're held by the licence holder, not the general public. So it isn't sort of a general licence for anyone to enter the property.
Okay. And sorry, Warrnambool, I did promise to come to you. Is there any questions from Warrnambool?
Yes, I do have some concerns. The Australia-China Free Trade Agreement is due to be signed this week. It's being promoted by Deloitte Access, who advised the government, and they were saying that this will be a means of providing gas to China to help China to clean up its atmosphere. I think there are other ways that they could clean up their atmosphere. And my concern is that the signing of this agreement will commit us, because once you sign a WTO agreement, it's just about impossible to pull out of it. For instance, France was taken to the International Court by Canada because France did not want to accept asbestos. And that is the only instance in all these years that an FTA has been decided, the decision has been made in favour of people and the environment. And in actual fact, it wasn't made on the basis of the effects on people and the environment. It was made on other evidence. So we have no powers once that free trade agreement is signed. We lose our autonomy, and free trade agreements can actually override the legislation that's internal in countries made to protect people and the environment. So therefore, we should all, everybody in this conference, should be doing their utmost to place pressure on the government not to sign this agreement until it's been written in that we have to have any of this gas mining done after we have had a scientific assessment of the effects. And also, I would recommend that people read the report which has recently come out from Environment America about the gas, the unconventional gas, and the damage that it's doing.
Thank you so much, everyone. Thanks for participating today. We will be distributing an evaluation survey together with a copy of Samantha's slides and the links to the various documents we've referred to today. Appreciate your participation and hope you've enjoyed today. Thank you very much.
Well done, Madam Chair.